May it please the Court, my name is Newendorf Initial E. I appear on behalf of the accused James Beetson, who is a 14-year-old Aboriginal male from Townsville, charged with 5 counts of breaking and entering premises and committing an indictable offence, and 32 counts of burglary, pursuant to the Criminal Code. Your Honour, I note that the Crown's case relies exclusively on the admissions made by my client. However, the defence submits this application via Section 590, capital AA, subsection 2, paragraph E of the Criminal Code. The defence seeks that the Court exercises its discretion in excluding the Crown's evidence relating to the confessions made by my client to the police officers. Whilst the Crown's evidence is admissible, I submit it should be excluded on the following 2 grounds. Firstly, I submit that the evidence in question was obtained in contravention of various statutory requirements, namely the Police Powers and Responsibilities Act, the PPRA. Therefore, the police officers have contravened public policy. Secondly, I submit that my client's confession occurred due to gratuitous concurrence, and therefore holds substantial prejudicial weight. It is argued that submitting the evidence would be grossly unfair to the accused. In respect to the first submissions, the defence submits that the police officers who engaged with my client failed to comply with their legal obligations under the PPRA. Specifically, I draw attention to Section 418, subsection 1A, which states that before a police officer starts to question a relevant person for an indictable offence, the person must be informed that he or she may telephone or speak with a friend or relative to inform that person about their whereabouts and ask them to be present during questioning. Police officers are required in subsection 2 to delay questioning to allow for this to happen. Mr. Beetson was unlawfully questioned multiple times regarding the alleged offences without any indication of his rights. During questioning in the police vehicle, my client was alone and could not contact a support person, resulting in a clear breach of duty under this section. Section 421 of the PPRA relates specifically to the questioning of a child. Schedule 4 of the Youth Justices Act defines a person under the age of 17 as a child, and therefore includes my client, Mr. Beetson. The police officers reasonably suspected he was a child, as on multiple occasions they referred to him with expressions such as young fella. Section 421 further requires that my client should have been allowed to speak to a support person prior to questioning. Whilst the defence acknowledges that Mr. Beetson was later provided with a support person, there was never an option for him to attempt or contact to speak with someone of his choice. Instead, that decision was made for him by a police officer. An onerous duty is placed on the police officers to offer my client a support person of his choice. Your Honour, Mr. Beetson was never afforded this opportunity, resulting in another breach of duty by these officers. Further non-compliance of the officer's duties is highlighted under Section 431, subsection 1. The officers were in breach by instructing my client to answer the questions rather than inform him that he did have a right to silence or to speak freely. Your Honour, you have the discretion to have these admissions excluded from evidence. In order to exercise that discretion, I direct the Court to the case of Bunny and Cross, which provides 5 factors that need to be established when determining if on the grounds of public policy, the evidence in question should be excluded. The number of breaches undertaken by the police officers clearly indicates that this was a deliberate breach, lacking any practical reason. The officers disregarded their duty under the PPRA for convenience. Although the defence acknowledges that the high cogency of the prosecution's evidence, the probative value is significantly diminished due to the various breaches to the PPRA. The officer's unlawful conduct was not in response to any pressing circumstance that indicated the evidence was going to perish or diminish. Significantly, they had ample amount of time to lawfully abide by the PPRA and call upon a support person for Mr. Beetson's choice. This conduct has clearly breached statute. The severity of these offences is slight and of an insubstantial nature. I respectfully submit that the exclusion is in favour. The defence asks that the same discretion be exercised in this case as was in Bunning and Cross, and therefore asks that the Court deem this evidence inadmissible. In relation to the second ground of of my application, the defence submits that admitting such evidence would be unfair to my client and should be excluded due to the Christie discretion. I note particularly Section 130 of the Queensland Evidence Act that refers to the exclusion of evidence. I refer to the Queen and Hasler, whereby an exclusion should only occur when the questionable evidence is of relatively slight probative value and the prejudicial effect is significant. Two key factors considerably determine that the probative value to be substantially low and the prejudicial effect is quite considerable. The probative value of my client's admission must be lowered due to the unlawful conduct. The opinion of my client's guilt by the jury may be skewed, as the Crown's case relies exclusively on the admissions made by my client, in which he admits his guilt to the alleged offences. This would have significant consequence to my client, creating a high prejudicial effect. Based on the effect of outweighing the slight probative value, I submit that the court exercises the fairness discretion to exclude Mr. Beetson's admissions. My client's ethnicity is relevant and must be considered. Gratuitous concurrence is when an Indigenous person appears to assent to every proposition put to them when they don't agree. This particularly occurs under the influence of authority and unfamiliarity, through intimidation, or often to indicate respect. It is evident gratuitous concurrence has occurred here. Mr. Beetson was intimidated by the police officers' unlawful questioning and also their leading questioning technique. This resulted in my clients admitting to an untrue confession of guilt. Mr. Beetson did not comprehend the consequence of his answers to those incriminating questions. I submit that the court considers the admission of guilt to be held inadmissible. Your Honour, I humbly ask that the court considers these submissions. Thank you.